the participants in my role as moderator to collate the views and then facilitate the discussions. I just thought that maybe a few minutes of introduction to this topic of voluntary liquidation. This process has been introduced in 2017 from 1st April. And I believe Section 59 in IBC provides a much easier kind of a route for a company to exit from the business for good reasons. That is, the business, has not met with any default, is not being closed for the purpose of, any, kind of a defrauding any creditor, not with that kind of any objective. So for such cases of a straightforward closure and exiting the business, this has been proposed as a route under IBC. Some of us may be wondering why it should come under IBC, a voluntary liquidation, which has got nothing to do with insolvency. I'm a well regulated person, a responsible person. I have been complying with all kind of regulations. I have not defaulted to anybody, but I just want to exit from the business. So why it should come under IBC? Probably I think that may be lingering in the minds of some of the participants. Then in that case, what is the other alternative? Where I should knock the doors to get out of the business? Companies Act. Okay, so companies are regulated by Companies Act. But Companies Act provides for a provision called strike-off under Section 248. A company can voluntarily go for a strike-off action to remove the name of the company from the register of members. Section 248 also talks about delinquent companies where the ROC can take the hammer and then push the company out of the register of members, register of companies. So it's a kind of an action, punitive action taken by ROC to remove certain companies which are not complying with the Companies Act provisions. So going there under Companies Act actually puts the whole process in the hands of a ROC and Ministry of Corporate Affairs, which is a time-taken process. Again, a public notice is involved and they group a lot of companies. And then finally, they say this company's name has been struck off from the register of members. So there is a comparison between these two routes. But today, our focus is going to be on the IBC process of voluntary liquidation covered under Section 59 of IBC. And there is a regulations, IBBI regulation, which has been amended 2 times in April 2022 and also in September 2022. So with that backdrop, I just thought that we should go ahead on making a small presentation. I will not take much time of the participants. Before going to that presentation, I just thought that I can also share kind of a situation where, analogous to voluntary liquidation, participants may be remembering about Go Airline, which has gone to IBC for a Section 10 on a Section 10 application. So can I call this Section 10 process as a voluntary CART process? The company itself is lifting its hands that I am defaulting, please rescue me, please save me. So the Go First Airline, which is, which was in the news for all wrong reasons, they were the first to come and first to get the order, first to get a court protection, all sorts of things happened in Go First. So Go First is a voluntary insolvency resolution proposed by the company. So analogous to this, similar to this, Section 59, the companies are voluntarily approaching NCLT for getting out of the, the company regulation, Companies Act regulation process to to exit from the whole process. So where under Section 10, a lot of provisions are there, IRP, RP will be there coming into picture. But here under a voluntary liquidation, a sort of flexibility is given, freedom is given to the corporate entity. So the board, the shareholders, they take a call on the voluntary liquidation and they propose an IP, an insolvency professional, to be the liquidator to run through the process. I have found certain interesting aspects in the voluntary liquidation in comparison with the normal liquidation process. After a company fails to get a resolution plan, it goes for liquidation. So there is a normal liquidation and there is a voluntary liquidation. So how does it compare in some areas? What are the differences? So I just thought that maybe with that a small little prelude to this concept of discussions today, a 10-slide presentation, and thereafter I will open this discussions for comments, suggestions, and ideas and inputs from all my learned friends, insolvency professionals. So I now would like to make a presentation, share a presentation on this voluntary liquidation. Just 1 second. Mute. The screen, is it visible to the participants, sir?
Yes, sir.
Ladies and gentlemen.
Yes, sir.
Oh,
Yes, sir.
Okay. Thank you very much. Let's go ahead. So the voluntary liquidation process, let me just quickly run through. So today's discussion will be on the discussion paper of 5th October. Please go ahead. The contours of the discussions today is most on Section 59 of IBC and then the liquidation process regulations 2017 as amended to September 2022. Go ahead. Why voluntary liquidation? Why not strike off under Section 248? We had a brief discussion on this topic. Go to the next. Critical issues in proper closure and exit from business. Many of the companies want to exist from the business without any associated liabilities on a future date. So they want a kind of a proper closure of all obligations so that the liabilities do not haunt the promoters, the directors at any point in later, because God knows, after 10 years, after 5 years, after 20 years, sometimes issues crop up and then disturb the whole scenario of the promoters. So in order to avoid those things, what is the proper closure and what are all the issues involved? Okay, go ahead. The first thing in voluntary liquidation, the idea of having this Section 59 was to have a time-bound kind of a liquidation process. So earlier, the voluntary liquidation process provided for a 1-year window for a completion of this entire process, which was found to be actually, a longer period. So later on, in I think in in April 2022, this process was compressed into a 2-time slab process. One is to know that where creditors are there in the company which is going for voluntary liquidation, where their decisions are involved, a period of 270 days will be the time limit for completion of the process. And a company where there is no debt, all their obligations have been completely fulfilled, and there is no creditors, then in that case, the time limit for completion of voluntary liquidation was curtailed, was bring down, has been brought to a limit of just 90 days. I think this is a provision which came into effect from 5th April 2022 in order to compress the timelines and make it a very effective one. We will see how this has worked in actual practice. Okay, go ahead. Yes, as I said, that creditors, they have to pass a resolution for voluntary winding up. So in which case, the timeline will run from their resolution to 270 days. Otherwise, in all other cases, the timeline prescribed under regulations is 90 days. Go ahead. The delays have been encountered in completing this process, and various kind of situations have come up, and regulatory compliances are the main hurdles. For example, distribution of certain payments to shareholders or stakeholders who are abroad. So example, if there is an investment by some NRI shareholders, and then that money has to go back to them, then there is a requirement of an RBI, compliances regulations. So there, many cases when the equity or contribution has come through Forex, the channel, proper channel through the authorized dealer, whether it has been done properly, in many cases there has been question mark. So those situations result in further delays. And another reason for a delay in completing the voluntary liquidation is in the realization of assets process. Sometimes the company has not been in existence, company has not been in operations for quite some time. Assets would have lost its proper backup in terms of legal requirements for a sale. And when the liquidator goes for a sale of the asset, a lot of question mark comes, and the title, the possession, all those issues come into play. And sometimes disputes amongst the members, stakeholders also result in delays and litigation. Go ahead. Valuation and sale of assets is also one area. Regulation 31 in the voluntary liquidation regulations talks about the liquidator may value and sell the assets, underline the word may, value and sell the assets of the corporate person in the manner and mode approved by the corporate person. So here, the kind of the flexibility or freedom given in the matter of valuation and selling the assets, what kind of a mode can be approached, what kind of a manner and mode can be followed by the liquidator, has to be approved by the corporate person. And also, if you can see the last line, in compliance with provisions, if any, in the applicable statute. It's a kind of a wide statement which takes into account what is the applicable statute. You go by the statute, but at the same time, the decision can be by the corporate person. So this is one interesting area which probably the members may like to debate upon. Next. Distribution. The distribution has to be done by the liquidator, has to be necessarily in the form of cash, or it can be in species also. So actually the regulation 35 talks about the distribution of the proceeds from realization. So there is no bar on distribution of assets, but then there is some kind of a stipulation that where the assets cannot be advantageously sold or realized, the liquidator can issue the assets to the stakeholders. So we will probably seek the views of comments of the participants on this aspect as well. Okay, go next slide. And transactions of avoidance nature, preferential, undervalued, and fraudulent, extortionate transactions. Section 59(6) of IBC makes a sweeping statement. It states that the provisions of section 35 to 53 of chapter 3 and also chapter 7 shall apply to voluntary liquidation proceedings for corporate persons with such modifications as may be necessary. So all the requirements of avoidance transactions will also come into play, and the liquidator has to have a proper eye on matters of avoidance nature. So this also calls for certain kinds of jurisprudence which has happened in this the few years of voluntary liquidation in place. Okay, go ahead. And the proposed amendments, which have been described in the discussion paper, they deal with 6 subjects. And very simply, very small, brief manner, I have just listed the 6 points. One, the directors to make further disclosures of pending proceedings at the time of making a declaration to go for a voluntary liquidation. I think this is the onus is shifted to the directors to disclose all such pending proceedings, whether it is relating to the FEMA regulation compliances or Companies Act compliances. All those disclosures have to be made by the directors. And the second point of proposed amendment is regarding the status report to IBBI on delay, which has not been there in place right now. So since the timelines have been compressed of 190 days in one case and 270 days in another situation where creditors are there, if there is a delay, a status report has to be shared with the stakeholders as well as IBBI. So this is another amendment. The next amendment is prior permission in the case of FSPs, financial service providers. So there has to be permission to be obtained at the time of passing the resolution to go for a voluntary liquidation. So this applies to companies in that financial services provider category. And the fourth amendment, withdrawal from corporate voluntary liquidation account. This is a kind of area, the time zone after the liquidator files the application for dissolution, but the NCLT's order on dissolution is yet to be made. In between the gap, if there is a claimant coming and approaching the IBBI, enabling provision has been provided in the regulations now by way of an amendment. And the next one is Form H and final report in electronic form to be filed with the IBBI. So this is also likely to save some time, in the process of compliances. And the Form H also has to be giving a good idea about the process completed by the liquidator. And the last one, dissolution order to be filed with IBBI. I'm seeing that some of the NCLTs are giving in their order itself under section 59, the dissolution order to be filed with the Registrar of Companies, and also IBBI, they have made it. But I think this amendment proposed is to have clarity that right now the dissolution order to be filed with the concerned registrar. For example, in this case of companies, ROC. So now the regulation amendment says that, explicitly the dissolution order has to be filed with the IBBI also. I think now they are talking about a period of 14 days to file this order. Right. So the discussion paper amendment proposes within 7 days. The proposal is talking about the liquidator shall forward a copy of an order under section 59 to the board, that is IBBI, within 7 days from the date of such order. Okay, anyway, we will talk about it in the discussions. So this is the situation. Where are you? So I would like to seek the views and comments from the participants, the fellow professionals on these matters, and any other related thing. Next slide, please. And any other matter also which would be helpful to the board to consolidate the views from the participants, and also take, in case any additional modification or amendment is required to the regulations, that is also possible. We can do that. So with that, I conclude my introduction on this topic, and I would now like to set the floor open for the participants. Please take the slide. Next slide.
Can I begin, Mr. Rajendran?
Yeah.
My name is Prakash Pandya from Mumbai.
Yes, Mr. Prakash.
I have 3-4 points. I would like to make it all in a go, if that is okay.
Yeah, please go ahead, Mr. Prakash.
See what I have been looking at, that these amendments does not, the proposed amendments in the discussion paper does not address many of the situations which are practically faced by the IPs today.
Okay.
இல்ல ஈவன் கண்ணா நீ கூப்பிட்டு கிளம்புற 8 மணிக்கே வரணும்னு சொல்லுதியா?
Mute.
If you could
நீ
please,
எங்கடா 9 மணிக்கு வந்து விஷ்ணு
Mr.
നിനക്ക്
Sridhar, if you
ജോലിക്ക്
could
വരണമെന്ന്
keep
ഇല്ലേ
yourself
നിനക്ക്?
on mute.
വന്ന വണ്ടി കഴുകണോ മസേജ് ചെയ്യാനോ രാവിലെ വന്ന് ചെയ്യാനോ ഒന്നും കാണുന്നില്ല. ഇന്ന് വന്ന് നേരെ കുട്ടിയുടെ വീട്ടിലെ പോയി ഇരുന്ന് വെച്ചാൽ വിളിച്ചു ചോദിക്കാനുള്ളതല്ലേ? വീട്ടിലെ മധു പറഞ്ഞിട്ടാണോ നീ ചെയ്യാനുള്ളത്?
Anjali, can you please mute the people who are not speaking?
Thank you.
Yeah.
And I'm making few recommendations also. So what I have observed, which many of us would have, like section 59, when we look at particularly subsection 6, it starts that from provisions of section 35 onwards it would apply.
Yeah.
So it doesn't apply particularly section 33 and subsection 5. So any litigation can still be commenced against the company in voluntary liquidation. That also puts onus of whether the IP need to conduct the board meeting and hold the annual general meetings. Okay, which I understand most of the IPs, particularly I am not doing it. Okay, so there's no clarity on this particular aspect, which I believe it's a high time for IBBI to categorically specify whether we need to have a board meetings and the general body meetings of a company in a voluntary liquidation. Also, as regards the payment of TDS and filing of tax returns. Now, we all know that NCLAT has already held that it is not required by the IPs, particularly those who are acting as a liquidator, to deduct the TDS and subsequently seek the refund because you are into liquidation. So you need not deduct the TDS while making the payment. You need not file the tax returns also. Okay, so whether we need to do ROC filing.
Okay.
So these are the aspects which practically affects most of us, I believe. So that needs to be taken care and brought in the proposed or the subsequent amendments. And this suggestion should go from all of us as a part of this group, and I believe also from ICSI IPA. So what I find that the regulation 37 in the voluntary liquidation provides that we need to provide and we need to have an annual status report till the date of filing of dissolution application. No, it says that till the date of order of dissolution. Now, if you look at the requirement under regulation 37 for annual status report, what am I supposed to do? So what I am required is that as part of the annual status report, I need to enclose the audited statement of accounts showing the receipts and the payments since the liquidation commencement date. Now, once I have filed the application for dissolution, I don't have any funds. I close the banking account. How would I pay the auditor? And we all know NCLT, due to practical problems that they are facing, you might have filed your dissolution application a year ago or maybe a couple of years ago.
Okay.
And are we supposed to hold annual status meeting with the stakeholders? Anyway, you are updating the stakeholders about what is happening in the voluntary liquidation. So I am unable to comply with this requirement because I don't have funds. I won't be able to pay the auditor to present the annual status report to my stakeholders. So I think that regulation 37 needs to be reworded. Instead of till the date of dissolution order, it should be till the date of filing of dissolution application.
Fine, sir. Very good. Very good.
I also have a couple of things, and then I will stop so that I can hear the others' concern.
Yes, sir.
See, the corporate debtor may not be aware, like what we are proposing, that they need to inform and inquire and disclose that how many cases are pending or the likelihood of the liabilities. But practically what I have seen that they do all this exercise. By and large, I would say the genuine companies we are talking of for voluntary liquidation. So they would inform or in the board meeting, they will record that these are the pending proceedings. Most of, particularly what I have seen is the foreign companies having offices here, because of a typical scenario of voluntary liquidation in their jurisdictions, they believe that now this pending compliances is the job of a liquidator. Why should I do all those things and postpone the voluntary liquidation process? So what I think we are proposing is good, that they disclose what
Yeah.
is pending, but at the same time, what is happening is that in one of my cases, they have disclosed what are the pending matters.
Okay.
But subsequently, a new claim comes up, which even they were not aware of, which is very old because the company was a manufacturing organization.
Okay.
Okay, so these are some of the issues which are being faced. Also, like some of the authorities like employee state insurance or provident fund authorities, they will never allow the closure. Like some of the registration, we seek the closure of the registrations with various authorities. Obviously, because there could be some claims of the employees, or employees might be continuing with the new employer, so they cannot close the registration of the corporate data. Okay, so certain clarity on this particular aspect may be given so that the IP knows the thing and need not waste its time and energy on the certain areas, which are very clear in as part of the process of the law, which are not clear in the statute of or in the rules or the regulations of those particular legislations. Okay, so even for the authorities who are dealing for them, IBC is a new still, unfortunately. And we need to educate them, and then we need to find a middle way to resolve the matter. So my suggestions, I will just summarize and seek clarification on Regulation 37 on the annual status report. I have already stated. I also seek the clarity on not holding of a board meeting and the general meeting upon commencement of voluntary liquidation. There is a need of a clarity on no TDS or no tax return filing and no ROC filing. Also, I have a proposal that we should have something like pre-pay kind of a process in the voluntary liquidation, where a voluntary liquidator is involved when you are intending to go for the voluntary liquidation. And before commencement, that is before the approval of the shareholder, at least you are onboarded, so that you take a vein of a company with all the details at your end. So when actually the shareholders meetings are there, you are able to even have a fruitful discussion with the shareholders, and you can carry on the process and give the estimate or your trajectory to complete the process in timeline.
Thank you very much, Mr. Prakash. I think you have explained your points well. For the sake of brevity, Mr. Prakash, I have just taken note of your points, and I would suggest that we will continue the other participants' views also, and probably I would like to summarize towards the end. If there is any solution, probably the solution can come from some other participants as well. We will just check it out. And thank you very much. And may I now request maybe Mr. Vasudevan, can you please share your points, sir?
Yes. Good afternoon, all. I am Vasudevan, Company Secretary and Insolvency Professional. Mainly, I am handling a lot of voluntary liquidation cases. With respect to, straight away, I am going to the point with respect to Mr. Prakash Pandya's view. So I'm totally agreeing with his points, wherein all the areas you have mentioned, there are kind of I can't say gray areas. One kind of a suggestion I can make to him is with respect to the Companies Act provisions, wherein with respect to Companies Act, the company, what I feel is the company need not conduct board meeting or annual general meeting, where the status of the company itself comes to a different stage. Like it's once the company's proceedings of liquidation is commenced, automatically the status of the active gets seized and the company itself going into the mode of separate different kind of a mode. So it's a liquidation. So we cannot say that the company is active and the company have to conduct a board meeting or such AGM like that. But with respect to the tax returns and all, the tax laws, as long as the company exists, as long as the corporate will stands, the company has to file the voluntary liquidation, or till the company surrenders the PAN, they have to file as per income tax law, they have to file the tax returns. So the company have to file the tax returns. These are all the things we are taking in discussion with various forums and with the various charter accounting firms or all these things. Then with respect to the
Mr. Vasudevan.
disclosures with respect to the recommendations are in the discussion paper. I'll just take one by one. One is the first one is the disclosure by corporate person. So this in this area, the directors can make a declaration as pointed out by the earlier speaker. Afterwards, say after at the time of making the declaration, there will not be any proceedings or there may be one or two proceedings. In most of the cases, the ESIC or commercial tax officers or GST officers, they start proceedings only after they send notices, demand notices, only after seeing the public announcement made by the liquidator. So
Right.
under these circumstances, what should be the stand of the liquidator? This has to be discussed clearly. Because when we receive a demand notice, we got standstill, we don't know what to do. In one of my cases, what happened was a VAT department sent a notice. Actually, the amount of the claim by in the demand notice was so huge that the company has gone into the state of solvent to insolvent. So under these circumstances, we don't have idea of what to do. So the company is in the process of withdrawing the liquidation. So far, also there is no clear provisions that is another point we have to discuss it. So if the company does not want to withdraw the liquidation, the state want to withdraw the liquidation, what is the process? So actually earlier, in earlier the regulation amendment, it was the one of the point, but it was not given at the time of regulation. It was on the discussion paper in the earlier amendment, but it was not put forth in the regulation. It has to be taken up.
Okay.
Important thing.
Mr. Vasudevan, thank you very much. In fact, I would like to brief the participants that Mr. Vasudevan, according to my understanding, handles more than 30 to 40 numbers of voluntary liquidation cases. So I think your points are well taken note, Mr. Vasudevan. At the same time, I thought that we can quickly scan the views from other participants as well, so that their views we can gather. Actually, we are talking about only about 5 or 6 amendments. Okay, sir. And once
may I interrupt just to clarify what Mr. Vasudevan has said about the Companies Act? If we can cite a provision which says that if a company is into liquidation, it need not hold any board meeting and the general meeting. IP is there is no such provision under the Companies Act. As regards file no TDS and tax return, there is an NCLT judgment which is pending before the Supreme Court. Next hearing is on the 21st of November. If any of the learned friends want to know, it is a civil appeal number 4568 of 2022. 4568 of 2022. It's a Chief Commissioner of Income Tax TDS versus Om Prakash Agarwal, wherein the NCLT has clearly held that liquidator need not deduct any TDS and subsequently where he is required to seek refund. He is not required to file any income tax return. So what I have submitted is based on the legal position, and it's not some chartered accountant or law firms.
Okay. I appreciate, Mr. Prakash. As you said, we will also wait for the outcome of the legal proceedings to have a finality. So may I request the other participants, anybody would like to share anything?
Sir, I have a small query, just a small thing. My name is R. Hariharan. Just for my understanding.
Okay.
Sir, this Go First case, is it a case under Section 10 or is it a case under Section 59?
Section 10.
Section 10. Thank you.
Thank you, sir. Thank you.
Hi, good morning all. I am Venugopal Panikar.
Yes, Mr.
First
Venugopal.
of all, Mr. Rajendran, you did a wonderful, crisp presentation on voluntary liquidation, a subject which is that way bit boring than the CIRP process. So thank you for that. Now,
thank you, sir.
With regard to the problems faced currently, I was surprised. The biggest problem which I faced from the is opening of a bank account. are
Okay.
others also facing similar issues? Because none of the banks, even the best of banks, are still don't know how to handle a voluntary liquidation account to be opened. Because
Okay.
without the account, sometime back, IBBI has reduced the voluntary liquidation period to 90 days. And I can tell you, I was handling a matter. HDFC Bank took
Okay.
as much as 52 days to open a bank account.
Okay.
So that's an issue. So I feel the RBI needs to maybe undertake them through a training program or something, and the bankers need to be more up to speed on it. That's one issue.
Okay,
Second
Mr.
issue
Venugopal,
is,
Mr.
Yeah.
Venugopal, just 1 second.
Yeah.
We have our team members, Mr. Nageshwaran, who has logged in from Coimbatore, and also
Yeah.
we have Mr. Venkatraman, who is a retired CGM of State Bank of India.
Okay.
Actually, we are not able to see much of an issue in opening of bank accounts. Mr. Nageshwaran, can you just share in quickly, sir, any difficulty you have faced in opening any account for voluntary liquidation?
No, as it is, but what Mr. Panikkar is telling is clear. If we are able to guide the branch or place where you are going to get the account opened and go along with them, because if they try to apply the straitjacket systems and procedures, what the individual bankers have got for their own account opening, it is always because it is not clearly specified. What Mr. Panikkar says is right. It is not very clearly given in the account opening process. And
Okay.
every bank, even within the bank, different branches have got different thing.
Okay.
I can even tell here in one of our liquidation account, when we wanted to have a demat account opened for selling shares
Yes.
held by the company under liquidation, it took almost, we knocked on almost about 7 banks. And finally, one bank opened, and I tell you, the account was live only for 4 days.
Yeah.
Naturally, we closed it on the 5th day, but at least that bank was able to understand finally, and that banker was able to appreciate the model required. But even the SEBI or anywhere else, when you are going to have the account opening for a demat account opened for liquidation account, and then if we found that it's humanly not possible to get on with it. So process differ, but not a general thing that it is very difficult to have the account open.
Absolutely, absolutely, Mr. Nageshwaran. Probably the Ms. Manisha, just 1 second. The difficulty comes because in the voluntary liquidation, you don't have an NCLT order stating that the voluntary liquidation process has commenced in respect of this company. It is only by virtue of a resolution by the board resolution plus the shareholders resolution.
Extraordinary GM general meeting resolution.
Yes.
And followed by creditors resolution. I think wherever some claims are there. Maybe Mr. Venugopal, I agree with your point. Certain kind of awareness has to be provided to the banking community, banking system. Probably I think that will help. Yes, Ms. Manisha, please go ahead.
Yeah, it's not only about the account opening, sir. In one of my cases, it took me 1 year to close an account with IndusInd Bank, wherein I had to approach RBI. I filed a complaint with Ombudsman Cell, and then I got the account closed because the banking issue with the bank was almost closed by the company, so nobody was entertaining this. And to close that account took me 1 year, and the process got delayed. This is
some banks may insist Ms. Manisha to come in person to the branch for closing the account as well.
Nice, but they're not responding even then. This is one point. Second is 90 days is not practical. What I say is not practically possible because under income tax, under 178 section of the income tax, it says 3 months time has to be given to the income tax department to file their claim. Under GST Act also similar provisions are there under section 88, I guess. So those acts. They are giving 3 months time to file the claim, and we are saying within 90 days the company should be liquidated. So that's why practically it's not possible. And GST department keeps sending their demand letters, notice even my 3 intimation letters, final reminder has gone. It's been more than a year for a company. I have sent multiple reminders to GST department. Now after 1.5 years, they're coming with there's a mismatch in one of the return. There's mismatch in this 3B return of 17, 18, 89. So these GST demand notices, I am telling them, I clearly tell them, if you have any claim, please file your claim form. Sending notices for mismatch and all, this will keep on going for another 2 years and company won't get liquidated in that way.
Absolutely, absolutely.
And GST Act, it says if any demand is there, even during the liquidation period or after that, directors will be responsible for paying that. Section 88 of the GST Act says that as well. Subsection 3 of 88. So why would director take that liability or that undertaking to pay off the demand if it comes in near future after liquidation is over? None of the director will give this undertaking actually. So GST, so these are the hurdles in closing a company actually.
Thank you, Ms. Manisha. One small kind of a clarification, maybe the members may be aware. Way back in 2021, IBBI had given a very strong communication stating that there is no need for the liquidators to seek a no-due certificate or a no objection certificate from the income tax department under section 178, because they are supposed to see the public announcement and file their claims. And if they don't file their claims, it rests there. It's their funeral. So I think it applies to other statutory departments as well, according to my understanding. But nevertheless, to avoid litigation, it is suggested that the liquidator proactively informs them that this is a process which has been started and we are going to complete it. We have already published a public announcement.
This circular helped us a lot because earlier taking NOC was taking a lot of time, but section says 3 months is the waiting time as well. So that's the reason we have to wait for 3 months.
Appreciated, ma'am. Appreciated. I request
further to the so this is Preeti, and further to the issue raised, my problem is with the refund of income tax, where the lakhs of rupees is to be received by the company as a refund of the earlier year's filings, and there is no response from the income tax department within time. So the liquidation goes beyond 90 days or 270 days, or even 1 year or so. So though the liquidator is not required to have the NOC of the income tax department, but still the refund, the shareholders' money cannot be evaded,
Absolutely correct. Absolutely. Ms. Preeti,
so
you
that
are
is
from, you
I'm
are from which
from
place?
Mumbai.
Okay, well taken point. And I think
and another question, I agree to the bank account opening. ICICI Bank, we had a issue with, for more than 1 year, they were not able to introduce the liquidator's signature in the account. We went for renaming instead of opening an account because opening an account was more difficult. So the existing account was renamed to the company's name with the words under voluntary liquidation and the liquidator being the only signatory.
Absolutely.
So in that case also, ICICI had taken more than 1 year, and we were not able to, we are still struggling with ICICI Bank after 2 years to have this account in operation. The third question arising is when such kind of delays, there was another issue in closing the ISN. The CDSL was taking too long to close the ISN and taking the time beyond the prescribed days, 90 days period. So in such cases, when the liquidator at the end of the liquidation period has to issue the compliance certificate, and then there are these deviations appearing for no fault of the liquidator. In such cases, whether it is taken seriously, and when the liquidation is going beyond 90 days, there is no provision for any submission or intimation to the IBBI or any other authority. It is straightway saying that in case the liquidation goes beyond 1 year, then the annual meeting is to be held. But what happens between 90 days to 1 year, whether there is any intimation required? When we inquired with the IBBI, there was no proper answer. Only the person who was responding said, since there is no provision, then you do not have to do anything.
I think this proposed amendment, Ms. Preeti, I think to answer your query regarding this delay after 90 days.
The status report is there in the proposed amendment, but then currently the liquidators are facing these issues.
Yeah, absolutely. Your point is also well taken. I think Ms. Neena Bhatia, can you please share your views?
The last question was, the preliminary report is to be sent to the corporate person. But in
Right.
case of voluntary liquidation, the liquidator is the whole and soul for that. So it is to be sent to the old directors or the promoters, corporate person to whom it will be sent.
To the board of directors as well as the shareholders is my understanding.
Correct.
Because they have only taken the view, they have only taken the decision to go for a
So
voluntary
it will
liquidation.
go on their individual addresses.
Yes.
Yeah, absolutely, absolutely.
Thank you.
Thank you, Ms. Yeah, we would like to hear from you.
Sir, Neena Bhatia from Mumbai.
Yeah.
So despite having the circular that we don't require NOC from income tax, they are conducting faceless queries, and in my case, when I was just going to get an order, my matter got stale because they raised a demand for that. And for last 1 year, despite our replies to them, they are not responding and we are stuck over there. And another thing is, nowadays in Mumbai, ROC, NCLT, they are asking for ROC report. There also ROC is not ready to give reports. So we are stuck in those matters. So something needs to be done, because I don't think so ROC report is required in voluntary winding up, sir.
There is no requirement for a ROC
Yes,
report for
asking.
voluntary.
Yeah, because it's voluntary, sir. They are already intimated by the advertisement. Plus GNL2, we intimate them that we are going into voluntary liquidation, and they only register our final reports and change the status of the company into under liquidation. So I think so they are well aware that we are under process of liquidation. So if they have any queries, they can immediately stay there only and raise queries or send us notices.
Yeah,
Just
correct.
to add to what Neena has said,
Yeah.
in my case where ROC report was asked, ROC has submitted the report but failed to remain present in the court. Still the judges are not passing the order. Also, the ROC report says that no due from income tax should be obtained, whereas IBBI has already clarified.
Correct.
To voluntary liquidation, I have no income which I am showing to the judges from the financials. Still the matters are getting lingering. So I think as a group, from this particular group, a suggestion may be given to CSI IPA on this particular aspect about the ROC report and the no tax due certificate.
Correct.
There is no such provision even under Income Tax Act. There is nowhere it is provided. So if I go today, there are two issues of appearing before the tax authorities. They say it is all faceless. So they don't want to meet in person to explain the case.
I agree with you. We are also stuck for 1 year because of that.
Yeah, and somehow if you are able to go and meet the ward officer, he's not sure who will be handling your case due to faceless process, and then they themselves admit there is no provision. How can I issue you NOC certificate? You bring the court order, we'll reply. So this all, consumes more time. Nothing.
Correct.
Yeah, you are right. Yeah, absolutely.
Chandigarh is also insisting to make ROC and IBBI party to the application, and they have also directed me to submit revised memo party and submit the application again. They will 2-3 days, and they want IBBI and ROC both to represent the case there in case of voluntary liquidation. This is for NCLT Chandigarh only.
Correct. But that is not the intent of the government when they brought this voluntary liquidation. If they start involving all the parties, as a in the litigation process, I think it would become an endless one. So to cut short that only, I think the public announcement, and then if they are submitting a claim, well and good. Otherwise, I think it is done with them. Anyway, let's hear a few more participants, ma'am. Any other person would like to share any thoughts?
To a bank account opening, my bank was very cooperative. I could do that. I think I was lucky about that, hearing other stories. And ROC report, the NCLT bench had directed, the ROC gave the direct notice to the registrar itself, and the ROC was specific. They will not be giving an NOC, but they have filed a report of our compliances. That's it. So the bench was satisfied with it. It did happen. They did not ask us an NOC. They just gave a report on the voluntary liquidation process, which I have done by timeline, and the ROC office had submitted that. So NCLT bench has approved the application.
Okay. Ms. Sarumati, thank you for giving a clean sheet on opening of the bank account. You are from which place?
I'm from Kerala, sir.
Kerala. Okay, thank you, and appreciate your point of view. We have other participants. Ms. Deepa Venkat, I was able to see you for a second. Would you like to share something?
Yes, sir. One small difficulty we are facing in voluntary liquidation.
is on the PUFE transactions.
Okay.
So it is mandatory to do the transaction audit and report, because on our Form H we have to say whether we have come across any PUFE transactions. Regulations also mandate us to do that.
Correct.
Now in CARP or under process, I understand there is a possibility, because our debts are not fully settled. There is a good possibility there might be some audit required. Whereas under voluntary liquidation, where most of the companies would have only maybe a good cash balance or the for distribution and their everything records again, why would the IBBI mandate transaction audit, the cost and time for that, or why would the voluntary liquidator take the liability of certifying that there are no PUFE transactions without an audit? So that maybe they can liberalize that for at least voluntary liquidation. That would be a suggestion from our end.
I think the very basic, requirement of initiating a voluntary liquidation, it is not to defraud any of the creditors. I think it is there in the first instance itself. But then I agree with you. There is a regulation 40, ma'am, under this, voluntary liquidation. Can you please show that regulation 40? Detection of fraud or insolvency, where the liquidator is of the opinion that the liquidation is being done to defraud a person, he shall make an application to the adjudicating authority to suspend the process. I think the provision is there in the event of a stray case, a peculiar, unique case where there is some, cause for the liquidator to doubt the proceedings. It has been done with an intent to defraud somebody. I think that is the intent of the provisions, to give both avoidance transactions compliance and also this, regulation 40. The regulation 40 I just mentioned, where the liquidator is of the opinion that the corporate person will not be able to pay its debts in full from the proceeds of the assets to be sold in the liquidation, he shall make an application. I think they have combined detection of fraud as well as insolvency in this regulation 40. Nevertheless, I think when the company itself making all disclosures, the board, the shareholders, at that point of time, if there is any, kind of a possibility of a fraud, if it is not there and later it surfaces, I think it gives the liquidator a kind of a control, a power that he can act on his own and then bring the, voluntary liquidation process to a halt. Anyway, I take note of your point, Deepa ma'am. Any other participants? Please remove this. Yes, Mr. Astosh. Sir, you are on mute, sir.
So now audible?
Yes.
Yeah. I wanted to know that what should be the minimum fees for taking up this job of voluntary liquidation, because as per IBBI guidelines, that the fee should not be rupees 1 lakh, less than 1 lakh per month. If the client is not having so much deposits or say assets in his account, so why should I take the assignment?
Mr. Astosh, may I know, you said that the fee should not be less than 1 lakh, right?
Yeah. So that applies to voluntary liquidation as well.
No, is it stated anywhere?
Yeah, as per IBBI's notification.
So that is only for CIRP proceedings, not for
written as IP should not. So in this case also, I would be an IP.
No, you are an IP. There is no problem. But I think the structure of the floor level of fees prescribed. If I may show it, do you have IR?
In case of voluntary liquidation, the regulations provide it will be fixed by the corporate person.
Correct.
Exactly.
In case of voluntary liquidation, it's purely a negotiation between you and the corporate person. There is nothing laid down by IBBI.
Sir, one simple question I would like to ask.
Yes, Mr. Rajesh.
There is a company, there is no asset in the company, and corresponding entries against the losses of the company is the loan from directors.
Okay.
My question is, can this company adopt voluntary liquidation process? Number one.
No.
Question number two. Pardon?
Sir, this is not a forum for seeking suggestions and the answers. We are discussing on the discussion papers and the practical difficulties faced. Sorry for being blunt.
No. For in this case, there is no question. In discussion paper, this can be a query, no?
Yeah, one second, sir. 1 second. I don't know who.
I have asked.
I don't know who interrupted. 1 second, Mr. Rajesh. May I know the person who said that this is not the forum?
Prakash Pandya, yeah.
Mr. Prakash, just kindly bear with us.
Yes.
Let him complete his query, sir.
No, he started that unsecured loans are there. There are losses. Can you?
1 second, sir. One second, Mr. Prakash. Mr. Astosh, please proceed.
Yeah. As per the notification, it is given that the IP should not take less than rupees 1 lakh fees.
Okay, that point I think we have clarified, sir. We have already clarified that the fee structure given by IBBI in Schedule 2, minimum fixed fee is applicable only for interim resolution professional or the resolution professional. Okay, it is not applicable to liquidation process. In the liquidation process, because it is a voluntary one, it has to be a mutually agreed kind of a fee structure between the liquidator and the corporate person, be it the board of directors or the shareholders. Okay, that is the understanding. Regarding your point of, you are from which place, Mr. Rajesh? Astosh?
I am from Indore, MP.
Indore, MP. You only asked the question. No, I think Mr. Rajesh Kumar asked.
I have asked the question. The company is having only a loan from director and losses. So this is the.
Okay.
Can this be a voluntary liquidation case or because
no way? Sir, I think first of all, your understanding has to be very clear. A company can go for voluntary liquidation only when the company has no debts or it has assets which can be used for settling all the debts in full. Only in those cases.
Give me half a minute. Because in this case, loan from director, the directors has given the certificate. They are not interested to take back the loan from the company. They are waiving of the loan.
Yeah.
So in that case, there is no negative net worth of the company after getting that certificate.
So this is a liability. No, there is a liability. There is a debt. There is a debt, right?
Only from director which they have foregone.
Sir, whether it is director or any external person, when there is a liability, it is a liability.
Okay,
then
thank you.
What you should have done? Yeah, thank you. In the matter of the liquidator remuneration, I just want to draw. Can you please show Regulation 5? I just wanted to draw the attention of the participants just to give a clarity. That it talks about appointment and remuneration of liquidator. It says that regarding remuneration of the liquidator, the resolution shall contain the terms and conditions of appointment of the liquidator, including the remuneration payable to him. So, which means that it is a matter of arrangement, understanding between the liquidator and the board of directors of the company. Okay. Fine, sir. Fine. We can go to the next participant. Any queries, sir? Any comment on this discussion?
Sir, I am Ajit Jain here, sir. Sir, am I audible?
Mr. Ajit Jain.
Yeah. Okay.
Yes, sir. Please go
Sir,
ahead.
I was having the similar matter what Madam Neena was specifically saying about. We have started the voluntary liquidation, and then there was a income tax matter which has come up, in which the AO has denied the expenses for a huge amount. Then we have gone into the appeal, and we are in appeal since 2020, and this is 23. And still, because of the faceless assessment, it is not coming up on the board. We have been giving multiple reminders to the income tax departments. There have been few queries which has come from income tax department. We have replied to them, but it is still not coming up on the board, and no order is coming. and because of that there is nothing into the company, only there is the amount lying which need to be distributed to the shareholders, nothing else is there. But still we are waiting for the income tax proceedings to get completed so that this company can be liquidated. Sir, is there anything we can do about this?
Sir, this is regarding a refund claim from the income tax department, Mr.
No,
Rajit.
not refund claim. They have disallowed certain expenses for the previous years.
Mm-hmm.
And those expenses, we are into appeal. Expenses are in huge amount.
Okay, so possibly a claim from the income tax department of a disallowance of your expenses.
Yes,
Am
there
I
is
right?
no, sir, they have not filed any claim.
Right.
But we have received the notices from the income tax department during our voluntary liquidation process which was going on, and then which was disallowed. We have gone to CIT. After that, maybe some of the period of corona was there, so that the department was also not so active. We were also into some time, but given the less, it was a faceless assessment, so we could not
Mr.
do
Ajit,
much about it, sir.
Yeah, Mr. Ajit, my short query on
Yes, sir.
the point raised by you is this. Maybe some other participants may also assist me. If there is a disallowance by the income tax department, either it should result in some kind of a claim from the department saying that, your whatever profit or loss you have claimed, which has been disallowed, because of that, you have to pay a little more income tax, or your eligibility of a refund is reduced to some extent. So my point is, if the income tax department is not clearly saying this and they have not filed their claim also, I don't think it stops your voluntary liquidation filing the application for the final report and the application. Let the adjudicating authority be informed that this party was not even complying with the public announcement requirement, and they cannot delay this. I think you can straight away go to the adjudicating authority while filing your final report and the application, dissolution application. These things can be highlighted. Am I right, Mr.
No, but sir, sorry, sir.
No, sir,
Sorry to
NCLT
interrupt.
There is a demand, demand from the income tax
Yeah.
department. So we
NCLT takes note of the demands, sir, and they won't go ahead.
One second, one person at a time. Mr. Ajit, he says there is no demand.
Sir, let me finish. Sir, let me finish. First of all, this is a voluntary liquidation, so the company is solvent. Number one part. Number two, there is a demand. So currently, I am having a balance in my bank account which need to be distributed to shareholders. There are no other liabilities. Maybe some minuscule expenses are there. Other than there is no liability. So if I need to go to NCLT, to adjudicating authority saying that my liquidation is over, before that I need to distribute my shareholders fund.
Correct.
So if I distribute my shareholders fund and the income tax liability is still there, then there will be no way in case in future if that claim or any order comes out to make good that claim, then I'm not having any funds. So I'm holding on that fund. I'm waiting for that order to get completed. Then only I can go to NCLT. Otherwise, how can I go to NCLT without distribution of the funds and making my bank account zero?
We have given indemnity in one of such case. We distributed the amount and we have taken indemnity from the shareholder. We submitted that with the income tax, and based on that, we proceeded with the liquidation in one of our case. Actually,
sorry, ma'am, I didn't get you. Can you just please go
one
slow
of
and let me
case
explain?
also, yeah, in one of my cases, such an appeal was pending. So in that case, we distributed the amount to the shareholders, taken an indemnity bond from the shareholders. In case any liability comes up after disposal of this appeal, they will indemnify the department, the company, and they will pay off that liability.
Okay.
They gave that. Based on that, we filed the application with the NCLT. Though it is still pending with the income tax, they were convinced the indemnity bond given by
But
the
my case, sorry, ma'am, but my case is a bit of unique. There are around 55 shareholders.
There could
And
be
they are quite aged ones. So more than 60, 70 retired persons are there. Couple of persons after my voluntary liquidation, a couple of persons have passed away also. So this is an old company, very old company, and this is a unique matter which I am handling.
This is different.
Sir, Mr. Ajit, I think the
Yes, sir.
number of shareholders, their age, I don't think it matters. I think what Ms. Manisha is telling, I think you are well within those requirements. You said they have not filed the claim, right? First
Yes, sir,
of
they
all,
have
they
not
should
filed
have
the
filed the claim, whether it is a demand or anything. If there is no filing of the claim, then I think you can go ahead, distribute the money, and also take a protection from the shareholders that you are doing this, and if there is any possible instance of a claim or something, because just like that they cannot make a claim. Income tax department, they cannot make a claim. And you are well within your rights to go
Sir,
ahead.
fine, sir. Thanks for good suggestion. I'll just update you for one more thing. In
Yeah.
fact, since last couple of times, no, I have requested uh, during the shareholders meeting when many of the shareholders are already there. So the annual meeting I am doing. So in that I have requested, sir, we will park this fund into a bank account and we'll continue to liquidate the company. Whatever the income tax results will come, after that we will distribute the amount and we will dissolve the company. We will make the application to NCLT that we will dissolve the company. So shareholders completely denied that. They were saying, Ajit ji, matlab, you are coming at least once in a year in front of us and updating us, and we are regularly in touch with directors that what is happening into the company. Otherwise, then matlab, they were not so sure that what will happen to their money, because they were a bit scared also about their money also. So they have not allowed me to go to NCLT and put such type of application also, sir.
Sir, I think you need not be, curtailed or restrained by somebody to go to NCLT. You have the right. Yes,
Okay.
Mr. Nageshwaran. Yes, sir.
Yes, sir. Having heard, I think this is one irritant point in the voluntary liquidation particular thing. Income tax, majorly, maybe to a little lesser extent, the ROC related matters. Can this forum, probably through this forum, you can take a suggestion that the respective income tax at the commissionerate level, let us say if it is in Tamil Nadu commissionerate, like that, whatever the commissionerate level, they should have one nodal officer wherever the voluntary liquidation matters are pending related to the company. It may be in nook and corners of anywhere in India. That particular commissionerate should be the one person with whom the matters will be addressed. And if he is quite senior enough, because this happens nowadays in bankings, in insurance agencies, it happens. So what they can do on that is you can address this matter to that commissionerate, and he will be the one nodal person who will be able to handle this on behalf of all the concerned companies in the voluntary liquidation in that commissionerate. This could be a suggestion which can be taken.
Sir, in fact, I will say this suggestion we can do it for all the matters of IBC, because income tax, PF, everywhere they are coming very late.
Sorry, sir. Sir, the other areas we will leave it up because this is voluntary liquidation. Under voluntary liquidation, there are, one set of people where the directors are coming around with the details and they want to exit. So, the exit policy is very important to be there in IBC. That is why this has been also brought under IBC. So this being one of the important exit-related matters, any company which has been formed should be able to exit also. See, somebody was pointing it out that you have some foreign companies where they have come and opened, they have done everything, they want to close. And now exit, we are not giving them, it gives a bad impression.
Absolutely,
So
Mr. Nageshwaran.
this could be the suggestion from this forum, if everybody else also agree that way, that related government agencies, particularly ROC as well as income tax, they should have for commissionerate level at the highest level, one person who will be directly reporting on these matters. The moment you put this on a roll, automatic, everything of these problems of all us of voluntary liquidation matters and liquidators will be settled is what my feeling is.
Absolutely.
I fully agree with Mr. Nageshwaran for this suggestion.
Apply this to GST commissioners as well. They are bothering a lot, all the GST.
Okay.
Whatever.
It can be for GST, it can be for income tax, it can be for PF, maybe state tax, wherever
that is what I'm saying.
We can have these common email IDs and where we can put in all our claims and send our communications also at the starting of any of the IBC process.
It can
Very
be for
very
all
constructive
these,
suggestion.
Yeah,
It can
absolutely.
be for all
Absolutely.
other areas. whoever is the number one, if it is, let us say Bombay, the PF Commissioner number one, Bombay Chief Commissioner or whatever the designation, he is the nodal person, he is responsible. If you fix it that way, it works.
Absolutely.
I think that is the way today CP grants is working. If you people don't work,
I think it's a very wonderful suggestion. Incidentally, for the benefit of the participants, Mr. Nageshwaran is not only an insolvency professional in India, he is also authorized to practice as an advisor in US as an insolvency professional. He has cleared all those US exams. Thank you for this wonderful suggestion, sir. I think this will help in a very big way. That one person responsible to, as much as ease of doing business is important, exit from business also, a honorable exit, that too. It's not like a liquidation after resolution is not possible. Here it is a voluntary liquidation. The person voluntarily coming forward to say goodbye, and then he would like to settle everyone in a completely within the legal means. Okay, so thank you, sir. Mr. Hardev Singh, would you like to say something, sir?
Can I make a small point?
Yes, Mr. Madhusudan. Yes, sir.
Thank you. Good afternoon to all. And as far as the bank account opening and income tax NOC is concerned, I had been very fortunate. I didn't face any hurdle with that. But the biggest hurdle is ROC. And the NCLT never is satisfied after the notices. They give number of opportunities and maybe 10 or 15 hearings I'm facing. And after that, they finally pass the order. Again, the biggest problem now I'm facing is filing of INC 28. There is an automatic response from the system, and which talks about section 396, 394, 445, 466. If you give section 58, 59 subsection 8,
okay,
there is an objection.
Okay.
I talked to the ROC representative personally. He said, sir, we can't help it. This is a system-driven response.
Okay.
And unless you make that's 394, 396, but when I read those sections, they are not at all related to voluntary liquidation.
Absolutely.
And one section it quotes is 481, which is non-existent in Companies Act 2013.
It is all talking about 1956, I think, perhaps.
That issue. Yes, yes. And it is all some of the perils of AI, automatic approval systems.
Yeah.
Of course, I have written to IBBI, but that issue also can be taken up.
Sure, sir, sure. Mr. Madhusudan, you are from which place, sir?
I am from Delhi.
Delhi. Good point, sir. And I think this problem of V3, has been really haunting the company secretary professionals.
Yes.
Added to that, combined with IBC, I think it makes, all the more complicated and lethal.
Sir, we have not been able to file one GNL2 for declaration of solvency.
May I know who is speaking?
Preeti here.
Yeah, yes, Ms.
The company went into
May I first
liquidation
complete
in February.
one small more point? And
yeah.
Okay. This is regarding the payment after Form G is filed with IBBI. In one of my case, a very senior aged shareholder died.
So Madhusudan, just 1 second.
Yes,
are we talking something other than voluntary liquidation?
No, it is only voluntary liquidation.
Okay.
So when the shareholder dies, we have to deposit that amount with IBBI till the successor gets a succession certificate. And you know how long is the process of getting succession certificate. In the meantime, the legal heir also on virtually deathbed.
Okay.
And the IBBI stand was that unless we get a dissolution order from IBBI, we are not going to make payment to the legal heir.
Okay.
So that has to be taken up, because if there is a claimant who has got a succession certificate, we have to distribute it to all others. Then why only for this person it should be stopped? It should not be made dependent on dissolution order passed by the adjudicating authority.
Okay, sir.
Or facilitating.
So you are referring to Form G regarding unclaimed dividends and undistributed profits?
Unclaimed dividends. Yes.
Oh.
Yes.
Okay.
Thanks. That's all I wanted to make.
Thank you, Mr. Madhusudan. Yes, Ms. Preeti, you want to continue?
Yes, sir. The company has gone into liquidation in February 2023, and when this all issues of MCA V3 was happening, so that time we were not able to file any GNL2 for declaration of solvency. We had to like submit the physical copy with the ROC, saying that this is not happening and we are unable to file it. So that was a major issue. And even now, in another company, when we have filed this INC 28, it has been thrown again back to us for resubmission with the query that amalgamation sections have been mentioned. On inquiring with the ROC, we have been given the answer that this is a system issue and it is popping up in the system. We are not able to do anything about it. So you resubmit the form again as it is. Because there was no error in filling the form, like we had selected the IBC and section 59, but in their system they were shown section 396 and amalgamation.
Yeah, I think the same point, Miss.
Yes,
Miss
sir,
Preeti, I
that
think the
is.
same.
Yes,
Exactly the same problem, and many IPs are facing it.
Yeah, sir. I've
Correct,
taken
sir.
note of it. Let's go move forward, and then now that almost we have taken about 1.5 hours. We got another half an hour to go. I wanted to seek the views of the valuable comments from some of the professionals here who are into the core of voluntary liquidation. Number one, at the time of the declaration given by the board of directors, they are supposed to give audited financial statements of the company and also a valuation report. Am I right, sir? So that report on valuation is supposed to be done by a registered valuer. I'm talking about, you can show it on the screen, section 59(3). There is a requirement in the declaration. Audited financial statement and record of business operations for the previous 2 years. Report of the valuation of the assets of the company, if any, prepared by a registered valuer. So I think Mr. Vasudevan also is available. Mr. Vasudevan, in how many cases, the voluntary liquidation company cases, the directors are giving you a valuation report, Mr. Vasudevan?
It's very less. It's very less.
Compulsory.
Company is having sizable assets. Most of the cases, it will be having a bank balance.
Okay.
Or a few assets like few receivables.
Okay.
In all my cases, I have done almost 30 plus 35 cases. Only in one case, I have to get a valuation report. It's because the company was having a land.
Okay.
So in mostly all the other cases, since you have read about if any. So if required means we have to get, otherwise it's not required. So that's the interpretation we are taking it. So if it is required, we have to take it. Otherwise, it's not required.
So Vasudevan, I have one query here. I'm not a legal person.
Yes.
Next to that too. The use of the words if any, I think you also mentioned.
Yes.
Can you see it on the screen, sir?
Yes.
A report of the valuation of the assets of the company, if any, prepared by a registered valuer. My understanding is this if any should be closer to the assets, not the company.
Yes, you're right.
Or should it is not near the report, sir. It should not be near the report. It is not near the report. Yes. A report, if any, prepared by a registered valuer. It is not the option.
Yes.
If there is an asset, there has to be a registered valuer doing a valuation. That is my understanding. If there is any asset, okay. If there is a cash alone is the asset, probably we don't have to go for a valuation again. But yes, if there is some other assets, then there has to be a valuation to be done by a registered valuer. Would you agree with my point?
Yeah, certainly, sir. Certainly, it has to be. If even the company is having some other assets, even current assets or like that, the valuation has to be done. Valuation has to be done.
Okay. Yeah. Now,
Mr. Rajendran, can I add a small point here? If you link this with the declaration of solvency by the directors, they
Okay.
have to indicate the realizable value.
Okay.
So in that perspective, my understanding is that it may not be necessary to have a valuation report, and we can read it like, if the valuation report is there, it should be provided. If it is not there, not to be provided. Because in the declaration solvency, they indicate what is the assets and liabilities as on the date of declaration and what is the realizable value.
If I am the promoter, Mr. Madhusudan, I may be tempted to value the assets on a higher value. Probably I would say that, my assets are very valuable. The land here is very precious. And I would like to say I'm solvent. But in reality, the matters could be different,
That's
Right.
true.
If there's only cash and bank balance, only in those cases report is not required. Apart from that, in all the cases, it should be required. Even if there's some receivables are there, you report for that, what are the chances of recovery or not. So it should be there.
Yes, it's correct.
Absolutely. Now,
practically, it's not happening. No declaration is along with the valuation reports. Not in my case, at least, for 5 cases.
But is it not expected of the liquidator?
Definitely, the wording and interpretation, if any, all are taking it lightly, whether these are required or not. As Venu with, I think, previous speaker Venu Dhawan, Vasudavan. Sorry, I spell it wrong. Only we are insisting on when there is a fixed assets or something. Otherwise, the current assets, some receivables, and the bank balances, we are not insisting on that.
Okay.
This is a practical approach I am taking. I don't know about the others.
No, I think, sir, the point is, when there are any assets other than liquid cash, then there has to be a valuation and that has to be insisted. Unlike CARP, you don't require 2 sets of valuation here. It is only one valuer here. That is the requirement. And that has to be done by the management of the company, the corporate person, the board of directors. Mr. Vasudevan, I have one more pointed query to you.
Yes,
Can you show Regulation 31? Mr. Vasudevan, we spoke about the valuation report by a registered valuer, which is there or not there in many cases.
Yes.
Now, sir, you would have handled the case where other than liquid cash, there are some assets, possibly some assets are also there in a company?
Yeah, yes, sir. I have handled the case in which only the shares were the assets.
Okay, many cases the shares investment is there.
Yes.
Now let me take a case where shares are also there.
Yes.
Maybe a few more assets like a piece of building or some vehicles are there.
Yeah.
Land parcel is there. Maybe land parcel is into a lot of litigation.
Yes.
Now referring to this 31 regulation, sir,
Yes.
Whether you will be valuing those assets through a registered valuer again.
Yes.
And arrive at what is the amount,
yes.
And then selling the assets. When you are going to sell the assets in voluntary liquidation,
yes.
Many people do not have the opportunity to sell any asset in voluntary liquidation because the whole thing comes after a clean slate. Everything is done and dusted. Then it comes for liquidation.
Yes.
As a liquidator, am I supposed to go for an auction of the assets, in which case I have to follow certain process like in the normal liquidation process.
Correct.
And if you see Regulation 31, the liquidator may value, the use of words may value and sell the assets in the manner and mode, again important, in the manner and mode approved by the corporate person.
Yes.
Okay. So
yes.
I'm just highlighting this, whether the liquidators here in voluntary liquidation, are we going through this process in any case? How are we handling it? And it is saying that in compliance with the provisions, if any, in the applicable statute. So that is also mentioned here. It is not only the corporate person approval, also the compliance with the applicable statute.
Correct.
So
Correct.
I invite the views and comments from the participants on this particular aspect. Maybe Mr. Vasudevan or any other.
In case of any other assets, as you rightly pointed out the provision, in the resolution itself, we have to get a separate paragraph on this. All the corporate person has to give the approval to the liquidator, mentioning the provision that In this mode, you have to sell these assets like that. That kind of approval has to be given in the appointing resolution itself.
Oh, okay. Okay, that would be a right way to get a proper clarity on the assets as well as how to dispose of the assets.
Yeah, yes, sir. Yes, sir.
Okay.
As you rightly pointed out the provision, exactly it states that approved by the corporate person in compliance with the provisions.
Okay.
So whatever the approval they are giving, it has to be in compliance with the regulations, IBBI regulations, as well as they have to give the approval to the liquidator also.
Okay, okay. So shares, in some cases you said shares are there.
Yeah.
If they are listed shares, then I don't think there will be any problem because you can just offload in the market.
Yes.
But if it is unlisted shares, Mr. Vasudevan, then how do you handle, sir?
So in case of other shares, then in case of a private limited company shares, normally it's a kind of issue. I have not faced that kind of this thing. I am
okay.
Most of the cases I got a listed company shares. So we the market and we realize the money.
Okay, okay. Possibly, Mr. Vasudevan, the listed company, absolutely no problem. Unlisted companies, the liquidator can write to those board of directors of those companies saying that the shares held by this company, because we are now going into voluntary liquidation, can you find an alternate buyer for these shares and what is the price you can get? Because as a private limited company, the directors have the right to approve the transfers. Yes. Finally, they have to take the call. And these shares are held in the name of the corporate debtor, which is going into voluntary liquidation. Am I right, sir?
Correct, sir.
So I thought that may be the right way.
Yeah, that's why I mentioned that the mode has to be given by the corporate person itself. Okay. They have to suggest that this investment asset, you can sell it in this manner like that. They can spell out those. Okay. They can us. Yes, through the resolution.
Okay, okay, sir. Okay, very good. Now, next point.
May I add?
Yes, yes, please.
Arun Gupta this side, sir.
Yes, sir.
Yes, Mr. Arun Gupta.
So, because we are talking about, say, unlisted shares in a company which is under liquidation held as investment by that corporate debtor.
Okay.
And I've also not dealt with exactly the unlisted shares, but say, for example, there is some debtors in the books, which is recoverable from any entity. And as a liquidator, we made an effort, say, they said dues are, say, 1 crore. We sent a letter, whatever we did. Somebody is not paying. So the option before a liquidator to realize that is, say, either to file a case, maybe somebody sued, or whatever case is possible. And by using this language of the law, where it says that value and sell the assets in the mode as may be approved by the corporate person. So one of the options which we thought of and we tried also is that then we discuss with the corporate debtor, which means the shareholders. They say that, okay, that person was not ready to pay the whole amount. He was ready to pay, say, 50%.
Correct.
So there was a kind of a MOU entered with the permission where the shareholders were party to that agreement. So the realization was happened with the permission of the corporate person. So when you for unlisted, that means anything we can sell the shares, sell the asset of an unlisted company, of a company under voluntary liquidation in any manner whatsoever, with the specific permission from shareholder. That's what the way I try and interpret it. Yes, yes, we have to. Somebody may argue that it is below the value. Something where we could have realized it, but at the end of the day, that money belongs to the shareholder. They agreed to it. Then it doesn't matter. Should not matter.
Correct, sir. Correct. Okay.
Sir, you are also right that way, because after all, finally, this is a voluntary liquidation.
Yes, sir.
Correct. Absolutely.
The underlining thing at the end of the story, originally they thought of getting X amount from liquidation of the company, and if they are going to get X minus, because of this adjustment they need to do so that they can get exit. Probably who else will be the right person to decide? The corporate person.
Yeah, correct.
That's the right. That is the idea with which it goes.
Mr. Arun,
sir, I also have another suggestion, sir.
Yeah.
From the whole discussion, because one of the issue I understood that most of the people are facing is some notices came in between the liquidation process, maybe from GST, service tax, income tax, whosoever, assessment, whatever. So, and these things takes time, and IBBI always wants to close the liquidation as soon as possible at the fastest speed.
Correct.
Can we think of a situation where say something is going on and you can't really control any regulatory litigation or regulatory action, show cause notice, reply, they go as per their own timelines. So then again, I'm coming with that same logic. Anything which will come in future as a liability will be the liability of the shareholders of the company.
Yeah.
So can we mention somewhere that though it is mentioned otherwise also that company is solvent and directors or shareholders has made sufficient provision for any contingent liability also. But in such a situation where anything comes in between and we want to close the company, we want to distribute the funds to the shareholder and file a dissolution application. In those scenarios, can a mandatory indemnity clause be there? Maybe a mandatory indemnity letter from the shareholder for a specific notice received from GST, which is pending as on date, and let them say that we will incur whatever happen in this case, even post dissolution. That's innovative, because after dissolution, how the company will remain into picture, we don't know. But if something will be in the statute of law that can survive post that, and so that NCLT can dissolve the application also, because otherwise NCLT will never dissolve if anything is pending before any statutory authority.
Absolutely, sir. Absolutely. In fact, Mr. Arun Gupta, you are from which place, Mr. Arun?
I'm from Delhi. I'm from Delhi.
See,
like about 15-20 matters of voluntary liquidation. So.
Oh, very good, sir. Very nice of you. Thank you for sharing your experience and specific issue. If you go back to section 59.3, the declaration from majority of the directors verified by an affidavit that they have made a full inquiry into the affairs of the company.
Right.
And they have formed an opinion. The company has no debt, or it will be able to pay its debts from the proceeds of the assets. So, essentially, the directors should give, because directors are the people operating the company, not the shareholders. So, when you are going to distribute the monies finally to the shareholders, and you are going to put a string to that check. Look, gentlemen, I'm paying you 10 lakhs of rupees today, but I may come back to you and ask you to pay me back another 1 lakh for various litigations. If you say like that, I think it gives a lot of discomfort to the, the ultimate person, the stakeholder who is receiving the money. They are the shareholders of the company, let us assume. I have a feeling that we are letting go the main people who are responsible for the operations of the company and financial affairs, and who are giving a declaration that they have made a full inquiry into the affairs of the company. So the indemnity has to come from the directors, I feel. Maybe I request other participants to share this view.
Practically will be very difficult because a lot of companies have professional directors on the board.
Exactly.
Okay. Particularly after commencement, they have no role to play also. And if we'll bring an indemnity from a director, we have analyzed the situation where why people go for voluntary liquidation, vis-a-vis other options of closure. So say, for example,
from where will he pay actually? Shareholders receive the fund, so they should be the one who would pay the liability. And that should have been those notices that has been issued by the department before the dissolution application was filed with the authority. Any notice that is coming thereafter, those should be extinguished, totally, because there's no point of receiving notices even after the dissolution application has been made to the authority actually.
Because prior to commencement, this declaration from director is perfectly fine because they were managing the affairs of the company, so they have more information about the company. But post commencement for future liabilities, why a director will indemnify anything? Because he was just a director, not an owner of the company, and he's not a beneficiary of the funds of the company.
It's not a future liability, Mr. Arun. It is arising out of transactions which have happened
prior to that.
Prior to that, voluntary liquidation commencement. Okay, when you said professional directors may not digest this kind of a liability for them, they would not like to definitely, hold any such kind of a Damocles sword on their heads. So the option for them is to quit the board. Even if they quit from the board also, the liability for those past transactions continues to be on their head as well. Okay, so all the more diligence has to be applied by the board of directors. That is why this voluntary liquidation, a lot of flexibility is given. Like Mr. Vasudevan said, the mode and manner of selling the asset also is given a free hand to the company.
Yeah.
The corporate person is given that free hand. And unlike a regular liquidation, where as a liquidator, I have the comfort of the stakeholders consultation committee in a regular liquidation. I don't have this comfort here in the voluntary liquidation. Am I right, sir?
Yeah.
So I feel that, the kind of mandatory indemnity, as you said, on liabilities coming after the process has commenced, suddenly, as you said very rightly, beautifully, the regulatory authorities have the habit of throwing a big bombshell into the process that I have so much of claims. Nothing has been done. They would miss the bus. Definitely, they would have missed the bus in filing the claim. But later, they come blazing guns with lot of claims, with lot of huge amount of these things. So that's an area where I think
practically, I as a liquidator always take such indemnity from shareholders. But that is for my protection. If anything comes in, but I always have to argue it before the shareholder or the board because they don't want to give it. They generally argue it. But at the end of the day, I always made that effort. Ki bhai, mujhe I need that indemnity. But sir,
if Mr. Arun,
legally to that point, there is something in the compliance form also in form match. If you can go to the last clause of that, if you can open or share that on the screen.
Yeah. Form match.
It's there, I think.
In the last clause, it is covering the contingent.
Yeah, yes.
Yeah, it is
in the regulations as the last form H.
Form H point number.
Last portion.
Last point, I think so. It's last point.
I hereby certify all undischarged matters pending, if any, before any court or tribunal have been reported to AA along with the details of provision made to sufficiently meet the obligations arising from such pending litigations. Point number 10. Are you referring to this?
Yes, I'm exactly referring. So this is somehow covering it, this thing. But the issue is, even if you will report to AA, they will not dissolve till the time it is concluded. So I'm just trying to bridge a gap between this issue. We have made a sufficient provision.
Moreover, this is what matters only. What about the matter?
But Mr. Arun, I have one query. I think this point also came up earlier. I am the liquidator in a voluntary liquidation, and I am supposed to distribute the money, all the monies, and close the bank account and go to NCLT for dissolving the company. Now, if I make any provision here, where that provision will be kept and who will be the administrator to decide on this using of this provision, this money, whether the court will take care of such eventualities?
Actually, sir, it's vague. That's why we are talking this, because it is somewhere covering, but then obviously you're right. You can't make a provision when the bank account is already closed. You have no money to make a provision. But then
exactly
can be made in the form of some, what we does is that we take a letter from a shareholder, attach that to the NCLT petition as a dissolution, quoting this clause. Then if this matter is pending and shareholder has confirmed that if anything will come in future, they will pay from their own pocket.
This is the indemnity from the shareholder. That's we discussed earlier also. But this is for the matter which are already pending before the court. What about any notice that comes up even when this is not pending at the stage of the liquidation period and it comes up after dissolution application filed with the department? I think for those claims, those demand, there should be a provision that stands extinguished if they have not raised any demand for that.
Yeah, that's.
Yeah,
you're right, because I've also received a couple of such notice in where application is filed and new notice came.
Right. What about those matters which may come up even after filing the application? Nothing has been provided in the act for that.
The moment we receive the notice in one of the matter, we start taking indemnity from shareholder.
But they can't give indemnity for uncertain amount. Now, even if the matter is not there, how can they give a indemnity for the amount which is not there? Maybe the shareholder itself is not solvent enough to pay that.
Because I can't think of as of now, but something can be done in clause 10 language.
I think, sir, one of the suggestions which probably Mr. Vasudevan also was trying to highlight, until all these issues are resolved, it would not be prudent to go for a voluntary liquidation initiation, because these are all, open areas, open-ended kind of things are there. If something comes from the blue, after the process is started on a clean slate, that's different. But if something is already
fine. You are right, because that is fine, that if any proceedings are pending, then you should not even allowed to commence it. Although there also a legal point is already there, sir. Section 59 says that to commence a liquidation, there are two main prerequisites. One is you have to be solvent. Second is not in default of making any payment to any creditor. Right.
Correct.
So how we will interpret the default if there is any pending proceedings with, say, income tax department, where they say they have raised a demand, we have objected to that, and can it be interpreted that there is a default? If we can interpret it just there is a default, then we can't even commence it. So then our life is solved, where we are saying if any proceedings are pending of any demand with any statutory authorities, then principally we are ineligible to commence it. But it is a gray area. It can be interpreted in this way also. The department is saying it's a default, but we are not saying it's a default. So in the eyes of board of directors, it's not a default. They have objected to the default or demand, and they have filed a petition. So
it is like your operational creditors and the dispute situation in a CARP. I think it always goes for both-sided arguments continuing. Well, I think we are having another 10-15 minutes to go, sir, and I'm glad to share that almost 100 participants are there. One question from my side, Mr. Arun, maybe the other participant, Mr. Vasudevan also. Once again, it is relating to assets and distribution. Can you please show on the screen Regulation 35? Mr. Arun and Mr. Vasudevan, is there any case where you are not able to realize an asset, a particular asset, and in turn, you decide that this particular asset as such can be given to one of the equity shareholders, or finally the money has to be distributed amongst the shareholders? They are the ultimate owners of the company. So when you are distributing this, you are distributing in specie, not in cash. Is such a thing prevalent, or you?
In Regulation 35, it's mentioned that under special circumstances or other special circumstances, there is a specific term used in the Regulation 35. So based on that, in one of my cases, what happened was the property, a piece of land just situated behind the airport runway of Coimbatore Airport. Because of that, nobody will want to buy the property. In future, it may be taken over by the airport authorities. So we tried to sell the asset almost for more than a year. We were not able to find an appropriate buyer. But then again, we have gone for a valuation, and we tried to distribute between the shareholders, because it's a big piece of land, more than 3.5 acres. Even the stamp duty itself, it was coming like almost 1.5 crores.
Oh, I see.
So we tried to distribute to the shareholders. Fortunately, the company was having only 2 shareholders. So I said, you try to take the property by yourself instead of selling to others. So they agreed, and we are now in the process of distributing to the shareholders.
Oh, I see. Okay. But then you told me at the initial stage in the board resolution, they have to say how this asset has to be mode and manner of sale. So did they mention there that you first try to sell it for the outside, and if it is not possible, then I will take it? Probably, I think they were also aware of this problem of airport.
Yes, sir. Actually, we at the second time we got their approval through a separate this thing. Because stakeholders, they have the power to direct the liquidator. In the second instance, we got the resolution passed by the stakeholders. Since we are not able to sell the property through the manner prescribed, so we can distribute among ourselves like that. We got a second resolution passed. Then, because of based on that resolution, we are processing for distributing to the shareholders.
Okay, sir. Okay, very good. So there has to be a valuation to be done, right?
Yes.
And it has to be done.
There is no specific regulation as such, but to be cautious, we are doing that. Anyways, in future, if NCLT asks me, on what basis you have distributed.
Exactly. Yeah.
Values this much.
Value.
And then you have distributed to the shareholders on what
Absolutely, sir. Yeah,
So-
it has to be
May I
through
also
a
add?
registered valuer, right? Through a registered valuer, you would have valued. Am I right, Mr.
Yeah,
Varun?
yes, sir, yes, sir, yes, sir.
Yes, Mr. Arun, tell me, sir.
So, sir, actually, I have not faced this particular issue. I have faced a different issue in this, which is not even before us as a query. Although I am not very happy with 35(3) clause. Well, this should not be in a situation of if it is in special circumstances or readily advantageously sold due to it should be an open issue, open thing for a company. Because again, I'm again of the same logic that anything which belongs to shareholder should go to shareholder, either in cash or in consideration. So
Okay.
this should be available to the liquidator to give it, yes, but then it should be incorporated in the beginning itself when somebody is commencing it. Because when you are commencing it and you know that there is a land and building in this company, because you know what we did in few of the assignments, when a client approaches to us, we say that you first sell this land and building, get the cash in the books, then commence the liquidation.
Correct.
So, although I wanted to suggest them, okay, let's proceed with this. We'll transfer the land and building directly to you as a shareholder. Say it's a holding subsidiary company. So anything which belongs to subsidiary is actually belongs to holding company. So there doesn't seems to be any requirement of putting such embargo to such transfer of asset in case of cash. This is one. And secondly, I have seen, I don't remember the case name, but this has also been passed or approved by Delhi NCLT in one of the matter where there was nothing in special resolution, there was nothing by the board, but the liquidator transferred the immovable asset to the shareholder, and NCLT has obviously approved the dissolution and the final thing, everything.
Okay, they did not interfere.
Yeah, they did not interfere, they allowed that.
Okay. Sir, Mr. Gopa, I think whatever you said makes a very...
But we did otherwise,
sorry.
just to add, sir, one thing. But we did otherwise, third situation, that in one of our matter, shareholder was one of the debtor also. So what we did is that we actually mutually set off it. That because money relies from the debtor and given to the shareholder. So, and I think that regulation 19 allows the mutual set off also between the creditor and the debtor. So
absolutely,
we set off that thing by obviously by writing letters, by exchanging notes, everything.
Okay, absolutely
that is also
fine.
kind of a non-cash consideration, if we say that.
I think, sir, where problem can come is the board is separate and the shareholders are separate, and even the shareholders are divided. So one fellow will say, how did you sell the land to the other shareholder at a throwaway price? So these kind of challenges may come where there is a divided kind of interest in the shareholders. But Mr. Vasudevan said only 2 shareholders are there in the company, and both of them probably the directors. Yes. I don't think any further issue will. Otherwise, it can give you some trouble. Well, sir,
maybe if this suggestion suits you, where we are writing that the liquidator may with the approval of corporate person. So I think whenever any asset is to be transferred, proposed to be transferred to this, so maybe this approval should be along with proposal for commencement of liquidation.
Okay.
So then everybody is on board.
Correct.
The director, shareholder, all shareholders are on board when you are commencing the liquidation. You know that this is going to happen in future.
Yeah. Yes, sir. Sir, Mr. Nageshwaran, you wanted to say something, I think, in between.
With regard to the same clause, that sufficient, because that paragraph 10, which we were talking about, sufficient provision should be made. See, whenever there is any clause where there is a relative term like this in sufficient provision, it always gets into trouble. That is one area. And as the 2 people just now suggested, the directors are supposed to have, as per your initial first one, 59.3, they should have inquired into every transaction of the company, taken a decision consciously to get into a voluntary liquidation.
Absolutely correct.
So, threadbare, all these things should have been discussed, and then only it comes around. Okay, so as Mr. Gopu also told, in the beginning they know that there was a problem. They tried their chance. Then later on coming around and agreeing for that. Okay, that is also permitted. But only thing, in the view of the time limits being brought in now, it should be better that all these transactions are covered right at the beginning in the discussion itself. That is a point which this 10 is a very very, very difficult paragraph. That way, which should not have been there, or it should be completely taken that it should be connected with that 59.3.
Yes, sir. Absolutely, sir. Point number 10 in the Form H.
Should be connected with 59.3 that they have already discussed threadbare, all those things, then only they have come here. Where is the question of sufficient then?
Maybe there are certain holes, there are certain issues. Still, I would like to make a provision and go for a liquidation, voluntary liquidation.
Provision is a question then. To you, to me, it is sufficient. For the other person, it may not be sufficient. So that becomes a relative term.
And maybe Mr. Nageshwaran, I would also interpret it in another way. The voluntary liquidation can go to a finality even if there is any pending decision by a court or tribunal. You can see all undischarged matters pending, if any, before any court or tribunal relating to a corporate person have been reported. There could be some pending issues, right? It is going on forever or something, it can continue for another decade, if left to choice. That should not bar this company from going for a voluntary liquidation. Can I take it that way? This point number 10, even if there is any pending litigation also, the company can go for a voluntary liquidation.
Yes, sir. Yes, sir. Actually, recently what I have done is, even yesterday I was discussing in one of the case, what happened was RBI, there was a compounding application with RBI. We filed almost 6 months back. So we have been trying back and forth with RBI and no, this thing is coming. So based on these regulations, now they are going to stick to the regulation, all these things. So I suggested the client that why don't you give a declaration, a kind of a thing from the stakeholder, and we can move to further, we can move for filing the notice. Otherwise, everything is done. Only we are waiting for the compounding for approval from the RBI.
Okay. Correct, sir. Correct. Absolutely.
We are planning for same things, sir. It's been clearly mentioned, but only thing is what type of provision, how to make, whether we have to close the account, that is not clear. So we are getting a declaration from the stakeholders that once the compounding order is passed, we'll be making out from our pocket like that.
Absolutely, sir.
That's what Mr. Gupta was also suggested.
Yeah.
Absolutely, sir. See, actually, this is the last one piece that I would like to discuss, sir. If you remember the beginning itself, there are two streams of people, shareholders or people to whom the payments will have to be made. If there is a company in which only indigenous funds were there, no question, there is no problem. Like Mr. Vasudevan just now told, if there is a foreign funds involved and brought into the matters, now what happens at that point of time, when you make the remittance or something on that, then they put a block. Now, suggestion can be on that is wherever the second stream of persons are there, that funds have to be sent abroad. Outward remittances need to be sent. That clarification, that clarity should have been taken right at the beginning of filing the voluntary liquidation. And this one, a banker, AD should have been approached. Who is going to handle this application at that point of time? AD should be clearance, whatever is necessary. Now, coming back to my earlier suggestion, if it is necessary, Reserve Bank also should be having such a person in the local place of the important places, that he will be or she will be giving the final decision that this payment is going with this compounding, this amount, all those things will be happening. So even at the time of voluntary liquidation filing, this is all finalized.
Absolutely.
So that time limits everywhere.
Yes, sir. Sir, as such, we also have a time limit to complete this discussion. So, 270 days, we have 120 minutes. I think we are almost coming to the close. I have one quick question to Mr. Arun Gupta and Mr. Vasudevan. Sir, it is in the interest of the fellow professionals who are here. I'm not requesting you to, share any absolute information, but please do tell us and guide us. How is the fee structure working in voluntary liquidation processes? Are you I can see a smile, Mr. Arun. I'm just asking, is it a kind of a wholesome package or liquidator fee X and then rest of the things at actuals? Because some legal professional also is involved, Mr. Vasudevan?
Yeah, certainly. Advocate is involved. All these things are there.
So 2 minutes to Vasudevan, sir, and 2 minutes to Mr. Arun.
Yeah, certainly. Actually, it depends on the case, and straight away, if it is the amount when lying in the bank account, we need to distribute to the shareholders. Normally, the client, from client point of view, they think that simply it's our account, our money is lying in our bank account, and you are going to just distribute by doing some processes. How much? Why you want this much money? So that's the thing normally they'll ask. So we need to give a balance between those things.
Okay.
I think just now after reading our new regulation, just yesterday I was thinking that we can have a kind of like IRP or in liquidation regulation.
Correct.
We can have a kind of first 3 months, this will be our fee. After the second 3 months, it will be our fee like that. We can give a slab like that going forward.
Yeah, good suggestion, Mr. Vasudevan. Like a table given in CARP regulations, yes. But here it cannot be linked with claims. The claims will be absolutely nil or very few only, so it cannot be linked with claims.
But it based on the time spent by us. First 3 months we'll be having more. We have to spend more time on this. But after that, one it crosses the first 3 months. If we are able to file the application, it's okay. But if you are not able to file the application, some cases are there going, and then we have to fix some kind of a fee for that particular period. So likewise, we can fix 3 months. Say this will be the fixed fee. Then after that, every quarter this will be our fee like that. We can fix.
Absolutely, Mr. Arun, your view, sir. You are on mute, sir.
On mute.
Yeah, sorry. Yeah. So, first of all, we have to say this is a voluntary liquidation. Whenever it's a voluntary liquidation, we don't get an assignment just like at the last day. We generally, there's a good discussion between the management and the prospective liquidator before, well ahead, like a couple of assignments which I did, which discussed, say, in 2029, commenced in 2021, because few things were pending and I clearly advised them, complete everything, then we'll start. So that means practically liquidators are on board at a very initial stage whenever the management start thinking it. So I'm not with that idea, what Mr. Vasudevan has suggested, that the fees can be in the slab of that, because it is, at the end of the day, is what we will get as a liquidator is out of what a shareholder money is. So it's nobody's money, it's shareholder money. So we are going to get something which they will get as a remittance out of the balance money lying in their account. So they are paying us from the balance money. So nobody is going to impact because of this fees except liquidator and the shareholder, because all other creditors will be paid off for sure in the voluntary liquidation, because otherwise you can't do the voluntary liquidation if creditors are pending.
Yeah, yes.
The fees is clearly a thing between a shareholder and the liquidator. Secondly, because there are a lot of other things also involved into this, the way we structure it, because I just want to practically mention this also. Yeah. We definitely use what Regulation 4 of liquidation regulation says. We use that table to negotiate with the client. Very good. Law says that up to first 1 crore, you have to pay 5% if it is done in 6 months. Very good. We use that table, that the lawmaker has also given it kind of a thing, but yes, that's not mandatory under voluntary liquidation. So and that will always give you some benefit while you negotiate it, because I have seen in the market a lot of fees have been reduced in these cases. Yeah, and the future risks are too much. Like maybe process, it's everybody's choice. What somebody wants to do. Process wise, it could be. In some cases, could be like would not take much time, but future is very risky propositions are there. Correct. So the way we take some money from the liquidation account and we charge something to the shareholders. Yeah. Absolutely. Because that maybe for advisory, maybe prior to commencement of liquidation, whatever it is. Okay. But yes, so the fees is from the liquidation account company itself. Unless if there is no fund, then obviously you have to plan something.
Okay, okay. Mr. Arun, I think that was a good input to use the table under Regulation 4 of the normal liquidation process. Okay, unfortunately, in the voluntary liquidation, I think everything has been left open for the parties to discuss and come to an understanding. Doesn't mean that the money left with the equity shareholders, if it is huge, our fees also can be proportionately huge. They don't give that kind of fee structure. But finally, as you said, the liquidator has certain responsibilities. Is having certain, onerous duties also to perform. Some of the things, Form H compliance certificate, signing a Form H, I think is definitely, puts a lot of risk for the liquidator, whether he has gone through the entire process in an unbiased manner. Okay, for that also the fee structure demands certain payment. So having said that,
I'll interpret and add one thing. I'm not bothered about Form H compliance because that is anyway duty of liquidator. The much bothered point is because, once the liquidation started, liquidator entered into the shoes of managing director. So post commencement of liquidation, even after dissolution or whatever time may be, each statutory authority, because we have intimated to every statutory authority, liquidation has started, now we are the liquidator, communicate with us. So if anything will come in any future, any time, nobody is going to send notice to the board. Everything will come to the liquidator. So we are actually taking a future risk of the conduct of the company for the since incorporation till date.
Absolutely, sir. Absolutely. Well said. Correct, sir. Correct. Thank you so much, Mr. Arun. With one last point on the amendment proposed, sir, I would like to conclude this discussion. Can you please show it on the screen? There is a requirement, that is the regulation. Can you please show? Filing of the order of the dissolution with the IBBI. The amended regulation says the liquidator shall forward, I think I'm talking about the discussion paper, 39A amendment. The liquidator shall forward a copy of an order under section 59 to the board within 7 days from the date of such order on the electronic platform of the board to be notified through a circular by the board. So what I'm observing, sir, this amendment is talking about 7 days, for filing the copy of section 59 order by the adjudicating authority. But if I go to section 59, subsection 9 says a copy of an order under subsection 8 shall within 14 days from the date of such order be forwarded to the authority with which the corporate person is registered. So IBC section provides 14 days time for filing with ROC, but the IBBI regulation proposed amendment says within 7 days. And I think Mr. Vasudevan and other professionals also have the problem of getting the certified copy from the registry. Okay. So is it not, a little more kind of, more expectation from this thing? They are reducing the time. Should it not be 14 days?
Yeah. It should be. Why
14 days, sir. It should be 14 days because we are having a problem with it depends between NCLT and NCLT.
Okay.
And in my cases, Chennai NCLT takes more time than the Bangalore or Mumbai NCLT.
Okay, sir. Okay.
Very difficult to get within 7 days.
I would like to show, sir, in this context, one decision by, is it NCLT or NCLAT? NCLT. Mumbai.
It should be from the date of certified order.
Exactly.
Receipt of certified order.
Exactly. Yeah. I think, sir, proactively, the NCLT in one of the decisions of voluntary liquidation, final order, they have mentioned that the first certified copy, from that date, you take 14 days to file it with IBBI. I think this is in 21 International Company, which bench it is? NCLT?
Yeah, this is practice now. Even in my case, they have indicated that within 14 days of obtaining the certified copy, you file it with ROC.
This is
the practice rather than squeezing it to 7 days.
So shall we suggest to IBBI maybe to consider the wordings of this amendment in 39A regulation in line with this in practice?
Yes, sure, sir.
Yes,
Very good, very good. Absolutely, sir. Fantastic. I think thanks a lot to the participants. A lot of suggestions have come. I think the participation has been really very good. And I thank the Institute of Company Secretaries of India, ICSI, IIP to give me this opportunity. Yeah, someone wanted to say something? Anjali, are you there, Ms. Anjali?
Yes, sir, I'm here only.
Okay. I'm just summing up, Ms. Anjali.
Sir, thank you all the participants for such valuable.
Yeah, Anjali, 1 second, Anjali. So I thought that, a few suggestions which have come from the participants, particularly in matters relating to, the conduct of board meetings or AGMs during the liquidation process, whether it is, whether there can be more clarity. I think that is one suggestion given by Mr. Prakash Pandya. And thereafter, a lot of suggestions have come, particularly in matters relating to opening and closing of bank accounts, where difficulties have been experienced by many of the IPs. Of course, some of the IPs were sharing that they did not face much problem. And the other one is about the faceless queries of GST, income tax, PF. Mr. Nageshwaran made a suggestion that there can be a nodal officer can be made the responsible person so that all these issues can be resolved. I think that was a very good suggestion. And thereafter, Mr. Vasudevan and Mr. Arun, they were also making quite a bit kind of contribution to the discussions about the disposal of the assets. And also on the fee structure, I'm thankful to share your, like we have the COC wisdom and judicial wisdom. Let's have the IP wisdom as well, to conduct the voluntary liquidation process in a remunerative way. We are not saying that, our time also is, quite valuable, the kind of responsibilities and future risk, as Mr. Arun put it. And also on the filing of the certified copy, some of the suggestions have come in line with the judicial decisions. And rest of the amendments, I think they are absolutely welcome. Those amendments have been really helpful, particularly the first one relating to disclosure of pending proceedings. And the timelines, I think some of the participants said that 270 and 90 are not practicable. In fact, we are breaching those timelines, and 90 has been really, really very objective or optimistic, I would say. I think Ms. Manisha would agree with me. So 90 probably will have to be like 180 at least. Or would you like to put some number? How much you want?
180 will be realistic.
180 will be realistic.
Minimum, yeah.
Okay.
Sir, although there should not be any timelines, it should be just 270. Because it doesn't matter, just having one creditor will not increase the timelines of liquidation.
Exactly.
Increase the timelines of liquidation not because of, if there is a creditor, there will be payment. Payment is a one-day time. The issues are different. When even this discussion paper came, I strongly mentioned to the IBBI, having creditor, not having creditor will not increase the timeline. The timeline is for other reasons. But anyway.
Okay, so there is a kind of
it should be based on assets to be disposed of rather than
rather assets. Yes.
And some companies, they do keep one payment pending as a creditor to have 70 days.
Whatever I have started post commencement, at least 5,000 ka ek due chhod do, and then let's
because we'll get more time. This is happening actually.
Good, very good, sir, very good. So wonderful, sir, wonderful. I think that is the kind of the discussions today, and I thank you one and all, profusely for participating in this roundtable. And it was really a very enjoyable kind of a session for me in person, because we could learn a lot of ideas from fellow professionals. So thank you very much, all the participants.
Thank you.
Thanks again.
Thank you, sir. Thank you.
We'll be happy to interact on some other.
Thank you.
Thank you, sir. Thank you.
Anjali, would you like to say something? Or you have already said?
So sorry to interrupt. This is Preeti
Share
again.
your views on the mail also.
Which email?
Anjali, I think if any suggestion they want to give, they can use the email ID of ICSI.
Sir, they can use my email ID. I'm just giving it on chat box.
Okay, very good. Yes, Ms. Preeti, you wanted to say something?
So one point which could not be discussed today was regarding the website of IBBI and ICSI IIP. wherein there are a number of disclosures in case of CIRP, but then there is no provision as such or much details for voluntary liquidation cases. We just get a Google form or a Excel sheet on email from the ICSI IIP at regular intervals, which we have to like fill in and submit. So
Okay.
if there is some disclosure directly on the website, that would be helpful, and there will not be missing out of any timelines.
Okay. I think it is the normal evolution which happens. First, the Google form comes, and thereafter they design, and then the website platform. So anyway, I will take your suggestion, Ms. Preeti. Okay.
Thank you, sir.
So thank you one and all once again. Thank you very much, sir. Ladies and gentlemen, thank you.
Thank you. Bye.
Thank you.
Thank you very much, sir, and all the participants.
Yes, thank you.
Thank you.
Thank you very much. Thank you.